All right. So, good evening, everyone. It's 6 o'clock. Thank you for joining us today for our presentation on the Paid Leave for All Workers Act, what workers should know. We'll get started in about 1 minute to give everyone some time to join us this evening. So, we're all glad everyone is here, and hopefully, this webinar presentation will be informative. So we'll be starting in about 1 minute to give people a chance to join. All right. So I'll just go ahead and get us started. It's now 6:01, and I want to be mindful of everybody's time. Good evening, everyone. Thank you for joining us. My name is Lydia Colunga Merchant. I am the Leave Rights Division Manager at the Illinois Department of Labor. And today's presentation is on the new Paid Leave for All Workers Act and what all workers should know. So, just a little bit about the Illinois Department of Labor. The mission of the department is to protect and promote the wages, welfare, working conditions, and safety of Illinois workers by enforcing state labor and employment laws, providing compliance assistance to employers, and increasing public awareness of workplace protections. So we're a team of about 117 passionate individuals, and together we enforce almost 30 state labor laws, and that includes the Illinois minimum wage law, the Illinois Wage Payment and Collection Act, the Child Labor Law. The Illinois Day and Temporary Labor Services Act, the Equal Pay Act, the Personnel Records Review Act, and now we have this brand new Paid Leave for All Workers Act. And there are many, many more laws that we are responsible for enforcing. So, some background on the Paid Leave for All Workers Act. So, the General Assembly found that it is in the public policy interest of the state for all working Illinoisans to have some form of paid leave from work to maintain their health and well being, care for their families, or to use for any other reason of their choosing. Illinois is one of only three states with a paid leave for any reason law. And to quote the act, the provisions of this act shall be liberally construed in favor of providing workers with the greatest amount of paid time off from work and employment security. So, on the agenda for today, we will be covering, these topics. What is paid leave? Who is covered under the law? Types of paid leave policies, such as accrual versus front loading. How workers can use and request paid leave. Additional employee paid leave rights. How to file a complaint under, alleging violations of this act. With our department, and we'll end with a question and answer session. So please be sure to save your questions for towards the end. However, feel free to put them in, submit a comment, but we'll get to those questions towards the end of the presentation. So there are four main takeaways we want all workers to understand after listening to today's webinar. First is that the Paid Leave for All Workers Act is not a paid sick leave law. We have gotten so many emails and calls from workers asking about the new Paid Sick Leave Act. And instead, the Paid Leave for All Workers Act entitles employees to earn 1 hour of paid leave for every 40 hours they work, up to 40 hours per year, for employees to use for any reason of their choosing. So, an employee can decide to use this for sick time, or they can use this for vacation, or if they need a personal day. It's just 40 hours that employees can use for any reason. So it's not just, sick days. To go along with that, if an employer already has a paid leave policy that provides you with at least 40 hours of paid leave that you can use for any reason, then your employer does not have to provide you with additional leave time. So, for example, if your employer has a vacation policy that you can use for any reason, you could use that vacation time for any reason, then your employer doesn't have to provide you with these additional 40 hours. It's just, again, this law provides a statewide minimum of 40 hours of paid time off for nearly all Illinois workers. Also, under this act, you do not need to tell your employer the reason for using leave, and you do not have to find another employee to cover your shift in order to take your leave. If you just put in that request for paid leave time, and your employer can then approve or deny that request. Your employer, like I said, may deny a specific, paid leave request, but they must have a reasonable and clearly communicated policy explaining why they would deny such a request. So, moving forward, what is paid leave? So, paid leave or paid time off is the time you take off work and are paid without getting penalized for it. So, there are a lot of other types of leave that workers may be familiar with and their employers may provide them with. For example, sick leave, vacation leave, some employers have bereavement leave, personal leave, and then we are familiar with FMLA or the Family Medical Leave Act type leave, etc. And many of these different types of leave programs may be paid or unpaid, depending on your employer or state or federal law that provide that type of leave. So under the Paid Leave for All Workers Act, most workers are entitled to earn up to 40 hours of paid leave per year. And again, as we mentioned, if an employer already provides their workers with at least 40 hours of vacation or paid leave time, and this policy was enacted before January 1st of this year, then again, those workers would not, be entitled to get additional paid time off because their employer has already met the requirements under the law. So again, it's not that the employer is exempt, it's that their policy is already in compliance. So as we mentioned again, your employer, there is nothing in the act that discourages an employer from having a number of different paid leave programs, such as paid sick leave, paid vacation, providing personal days, things of that nature. So the act doesn't require your employer to, modify that policy or to lump everything all in one. Um, Again, this is just, giving workers access to at least 40 hours of paid leave that they can use for any reason in a 12-month period. So, again, if your employer is already providing you with that, then they likely don't need to change their policy or provide that additional leave time. So, who is covered by the Paid Leave for All Workers Act? So, again, the Paid Leave for All Workers Act covers nearly all Illinois workers. And, the act defines employee as any individual permitted to work by an employer in an occupation. And so that includes, full-time workers, part-time workers, seasonal workers, temporary workers, and on-call workers. So, it's not the number of hours that you're working, that doesn't define whether you are an employee or not. So again, if you're, permitted to work by an employer in an occupation, and you're performing that work in Illinois, then you are most likely covered by this act. I do want to note for people who are domestic workers, you are also covered under this act. However, even if you are an independent contractor, and work as a domestic worker. So, for example, if you are a nanny, a housekeeper, a home healthcare aide, and you are, you know, a true independent contractor, you are still covered by the Paid Leave for All Workers Act. But again, that only applies to domestic workers who are also independent contractors. So again, who is not covered? So the act has specific exemptions, stating who is not covered by the act. And so that's that includes independent contractors generally, again, with the exception of those independent contractors who are domestic workers, certain railroad and airline employees, certain higher education employees, union, construction, and freight employees, park district employees, and school district employees are specifically not covered by the Paid Leave for All Workers Act. Those workers who are members of a union and covered by a collective bargaining agreement that was in effect on January 1st of this year, um, it's not necessarily that you're not covered, but it's that whatever is in your collective bargaining agreement is controlling. So it wouldn't be until your contract or CBA expires that the union and the employer would be able to negotiate over new paid leave terms and decide whether or not they want to waive that contract. So we mentioned that independent contractors generally are not covered by the Paid Leave for All Workers Act. However, there is a test that workers must follow in order to determine whether or not they are a true independent contractor. So just being classified as a 1099 employee, just having your employer have you sign a paper saying you're an independent contractor is not enough. You would definitely have to meet these three factors to be considered an independent contractor under the Act. So the first factor is that your work is done free from the control and direction of the employer. So the second one is that the work that you perform is outside the usual course of business. And then the third one is that you are an independently established trade, occupation, profession, or business. So if you as a worker do not meet all three factors, because you have to meet all three, then it is likely that you are an employee covered by the Paid Leave for All Workers Act. So as I mentioned, we talked a little bit about those union employees, so workers that are covered by those collective bargaining agreements. So again, if you were covered by a CBA on January 1st of this year and it was in effect, then the terms of that CBA will remain in place until the CBA expires. And this is even if that CBA does not provide for any type of paid leave. Again, it's when that new CBA is negotiated, then the parties may negotiate the terms of paid leave. If the employer and the union do not come to any agreement explicitly and clearly waiving the Paid Leave for All Workers Act requirements, then the employer must provide at least 40 hours of paid leave to those workers. So here's an example. The Hat Makers Union has a CBA with a hat factory that expires on June 30th of this year. So the union and the factory are negotiating a new CBA that starts on July 1st. They decide to specifically waive the Paid Leave for All Workers Act requirements and instead agree on 20 hours of paid leave and 30 hours of unpaid leave for workers. Therefore, the factory does not need to provide 40 hours of paid leave, as required by the Act. So what about those local ordinances? For those of us who are in, the northern part of Illinois, we may have heard about the city of Chicago's paid sick leave ordinance, or we have heard about Cook County's paid leave ordinance. So if you work in the city of Chicago or in suburban Cook County, you are likely covered by Chicago's paid sick leave ordinance or Cook County's paid leave ordinance and not the state law, so not the Paid Leave for All Workers Act. So if you are a worker who works in Chicago, then you would want to contact the City of Chicago's Office of Labor Standards because they would be the agency that enforce the city's paid leave ordinance. And the same goes for Cook County. For any questions relating to the Cook County Paid Leave Ordinance, please contact the Cook County Commission on Human Rights. So now we have some frequently asked questions that we get. Does the Paid Leave for All Workers Act apply to remote or hybrid employees? And does this act apply to employees who work in Illinois but live outside of Illinois or vice versa? So, the department has traditionally found that Illinois workplace protections, including eligibility for the Paid Leave for All Workers Act leave, it'll apply to employees who primarily perform work in Illinois for an employer that does business in Illinois. So, as we often tell workers, it's not so much where you live as it is where are you performing the work? So if you're a remote worker, you do all of your work in Illinois, and the company, even if they are out of state, if you're doing that work in Illinois, then it is most likely that you will be covered by the Paid Leave for All Workers Act. Again, because it doesn't matter where you live, it matters where you are performing that work. So now that we know who is eligible for leave, how can workers use paid leave? So first things first is there are two ways that the act allows employers to provide paid leave to employees. So first is that accrual method. So employees accrue or earn 1 hour of paid leave for every 40 hours that they work. And we want to note this doesn't mean 40 hours worked in a work week, it's just 40 hours total. So once you work a total of 40 hours, then you will have earned 1 hour of paid leave. And again, employees can accrue up to 40 hours of paid leave per year. A part time, temporary, or seasonal worker can also earn paid leave, but because they may work less hours over the course of a year, they may not accrue the full 40 hours of paid leave in that one 12-month period. So here are a couple of examples. So you have Kiana, who works 10 hours a week for a total of 40 hours a month, which means that she earns 1 hour of paid leave per month. So if Kiana works a whole year or 12 months, then she would earn 12 hours of paid leave per year. An example two, we have Bruno. He's a seasonal worker. He works 40 hours per week from May through September. And so he would then be earning 4 hours of paid leave each month. So again, it's all dependent on when you have worked those 40 hours, then you are entitled to that 1 hour of paid leave. So, some employers may decide to front load their paid leave. And so that just means that workers don't accrue their leave gradually throughout the year, but instead they're provided up to 40 hours of paid leave at the beginning of a 12-month period. So they get to, have all of their hours all up front. The 12-month period is not necessarily January through December, and it's determined by the employer. So, for example, it could be based on a worker's hire anniversary date. So, whenever you started working. If the employee separates, so for example, they quit, they resign, they're terminated before the 90th day of employment, they may not be entitled to paid leave. So, and again, the employer cannot ask you to pay the hours back if you have already used them. So here's an example. We have Powell works in a warehouse and gets 40 hours of paid leave front loaded starting on January 1st. On April 1st through the 5th, he takes his full 5 days of paid leave. So he uses all 40 hours. On June 1st, he quits and finds another job that's closer to home. His employer can't ask him to pay back his paid leave time that he used. So again, the employer gave all the paid leave hours all up front, and so they can't make him pay it back because he didn't work that full year. So, what about those overtime exempt employees? Oftentimes, we know that managers, professionals, other salaried staff who work more than 40 hours each week are required to earn 1 hour of paid leave per week under PLAWA. So, even if these workers or if these employees work more than 40 hours per week, they will only accrue 1 hour of paid leave. And so, we just want to note that the employers can allow employees to earn more hours under a more generous leave program, but the Paid Leave for All Workers Act sets that minimum. So, here's an example that kind of illustrates this. Lila is a manager at a local fast food Thai restaurant and is paid a salary. And she doesn't receive overtime because, again, she would meet that FLSA exemption for managers. She typically opens and closes the restaurant, which means she works about 60 hours per week. So even though she works those 60 hours, she's capped at 40 hours per week, so she only gets 1 hour of paid leave, for that week that she's working. So again, we just want workers to be mindful, like make sure you do meet those overtime exempt requirements, because there are certain factors. It's not enough that you're just salaried. We know that the US Department of Labor recently increased the amount of the salary you could earn to qualify for these exemptions. So just be mindful that you are actually meeting those exemptions. So when can employees use paid leave? So workers will begin to earn paid leave starting January 1st of this year or starting on the first date of work for employees hired after January 1st. And so employees can start using paid leave that was on March 31st, or 90 days after their first day of employment, whichever is later. So again, if there is that 90-day waiting period, your employer may decide to have a shorter waiting period before you can use leave, but the most that they can make you wait is 90 days. So here are some frequently asked questions that we've gotten. How does this work for seasonal employees who work less than 90 days per year? So under the Act, even seasonal employees are entitled to accrue up to 40 hours of paid leave per year. However, they may be unable to use that leave if they stop working before the 90-day waiting period. However, the Act does require employers to maintain records on the amount of paid leave accrued in the event the seasonal employee returns within a 12-month period. And again, do seasonal employees have to wait 90 days to use their paid leave every year? And the answer is no. So the 90-day waiting period only applies to an employee once during their employment. So for a seasonal employee returning, the next year, they would be able to use their accrued paid leave time right away. So again, it's like 90 days, like that only applies one time. So for those seasonal workers, it's not like every year they, get to accrue time, but then they don't use it. Like they have to, that only applies one time. So when someone is requesting paid leave time and they take it, employees must be paid their hourly rate of pay. So that could be, whatever your hourly rate is on your check. If you're salaried, it would be, whatever you're paid each week, divided by the number of hours that you've worked that week. For those tipped workers or employees earning commissions, they must be paid at least the full minimum wage rate for each hour taken. So for a tipped worker, this isn't the tipped minimum wage, like this is the actual full minimum wage. So in Illinois, the minimum wage rate is $14 per hour. So if you're a tipped worker and you request paid leave, you should be getting paid for that paid leave time at $14 per hour. So, how can employees go about requesting paid leave? So, the Act allows for employees to request to use paid leave verbally or in writing. An employer can, adopt a reasonable and clearly communicated policy that lets you know how you should request that leave. So, we always have a tip for workers, anytime you make a request or, say something verbally to your employer. So, for example, if you see your supervisor in person and you let them know, hey, I'm planning on going on vacation next month. I want to use my paid leave time. We always suggest that workers follow up with, that person, that works for their employer in writing. Like it could be email and text, form. An employer may have their own paid leave request form that you would need to fill out. All of that should be laid out in your employer's policy about how they want these requests to be submitted to them. But you can always let your employer know verbally, and then you can always follow that up in writing. So here's an example. So Jose's employer requires him to provide 7 days notice for a planned vacation. However, when he has to take an unplanned day off, such as when his child is at home sick and he has to care for him, Jose must notify his supervisor as soon as practical when he wants to take that paid leave time. And so again, under the Paid Leave for All Workers Act, you can take leave for any reason. It's in the law. So employees do not have to provide a reason for taking their paid leave time. And employees do not need to provide any documents or proof like a doctor's note in order to take your leave. And an employee can choose whether to use paid leave or any other leave provided by the employer. So, in other words, an employer cannot require an employee to use their paid leave time before any other paid or unpaid time provided by the employer or state law, and vice versa. So, here's an example. Lee's employer provides unpaid sick leave and paid leave. Today, she wakes up with a migraine and needs to stay home from work. She decides to take her unpaid sick leave in order to save her paid leave for an upcoming vacation. So, Lee's employer wouldn't be able to require her to take the paid leave time, because they have this other unpaid sick leave policy. And so Lee can decide, I want to take, my unpaid sick leave instead of, and I'll save up my paid leave time. But just a quick note, like this doesn't mean that your employer has to have some sort of unpaid leave policy or anything like that. So this is more if your employer has multiple policies that they provide. So for example, if your employer provides vacation, sick time, personal time, um, and then now they have this new paid leave time. You should be able to decide which type of leave you want to take and when to apply those hours. Like your employer can't make that decision for you. However, if your employer under this act now comes up with this policy and they only have these 40 hours that they're providing, that's this act doesn't require them to also create some kind of unpaid leave policy. It only requires them to have these 40. So if you want to take that time off, then you would have these 40 hours to work with. So can an employer deny a paid leave request? So the act does allow employers the ability to deny a request for paid leave, but it has to be due to operational necessity and it must be through a reasonable and clearly communicated policy. And so, again, this is why we have been encouraging employers to provide their employees with copies of their paid leave policies and how they want those requests made, as well as the reasons why they may deny those requests in some kind of written employee handbook that is also distributed to all employees. So here's an example that kind of lays this out a little bit clearer. So Petra's accounting firm has a peak season from April 1st through the 16th, right? Tax season. In the handbook, the firm lets employees know that leave requests will be limited during that period of time due to staffing needs. So during that busy season, Petra may deny leave requests, per the policy. So we are asking employers to, have a number of considerations in mind. However, um, employers under the act are allowed to deny a paid leave request due to operational necessity, so long as they follow that reasonable policy and they let the employees know why that paid leave request was denied. So, what are some additional employee paid leave rights? So, does paid leave carry over? So, if an employee doesn't use all of their paid leave during a 12-month period, it can be carried over to the next 12-month period. However, if your employer front loads all your paid leave time, so January 1st, you got all 40 hours, um, then that paid leave time does not have to carry over if you don't use it all. So again, even if an employee, has accrued leave time that carries over, an employee is only entitled to use 40 hours each year under the act. However, your employer may allow you to use more, more leave time, but the act just states that employees are entitled to use 40 hours of paid leave per year. So here are some examples that kind of outline this a little bit better. So Malik earns 40 hours of paid leave in 2024 and he doesn't take a day off. So he has all 40 hours that carry over into 2025. So he starts the year with 40 hours. He could earn up to 40 more hours of paid leave, but his employer may decide to only allow him to take 40 hours of paid leave total in 2025. So even though Malik could, by the end of the next year, have 80 hours to use, his employer could only decide to let him use 40. Here's a second example. Walter works 20 hours per week at a coffee shop and accrues 20 hours of paid leave time in 2024. He uses 10 hours of um, of paid leave and he rolls 10 hours over into 2025. So in 2025, um, he continues to work 20 hours a week and he accrues a new 20 hours of paid leave. So Walter now has 30 hours of paid leave to use, which is more than he accrued in the year. So here, because again, the act states that employees are entitled to use up to 40 hours of paid leave per year. So even though Walter typically earns 20 hours of paid leave, because he had those extra 10 hours to carry over, he could use up to 30 that next year because the act allows him to use up to 40. So, payout of leave time. So, we get a lot of questions about whether an employer has to pay out the any unused paid leave time when they leave their employment. Um, so under the Paid Leave for All Workers Act, employers are not required to pay out any accrued unused time if you quit or if you're fired or you leave your employment for any reason. However, there may be certain instances where um, a vacation payout may be required under the Illinois Wage Payment and Collection Act. So, for example, if your employer has a vacation policy or general PTO policy that maybe was in place prior to January 1st before the act went into effect. If your employer says, I'm already complying, I give you 80 hours of vacation per year, then it may be that they have to pay out, any unused accrued vacation because this is a vacation policy. It existed prior to, the act going into effect, and the employer never modified that policy. Um, or if the employer has some kind of PTO bank and they just mingle all the leave all together, then that's something that they may be required to pay out any of that unused time. However, if this is just where employer created this paid leave policy because the act went into effect, and they're following the act to a T, then they are not required to pay out any accrued unused leave. But if you do happen to have, um, a vacation payout claim under the Illinois Wage Payment and Collection Act, you can file, that complaint with the department. However, that would be a wage claim and not a leave rights claim. Additionally, we know there may be some employers who may offer to pay out, um, any accrued unused time at the end of the year to their employees instead of allowing them to carry it over into the next year. Um, this is something that employees can decide whether or not they want to accept or not. So, if you want to accept the payout, you can. Just make sure that everything is in writing, that you're consenting to that payout, and it's voluntary. But you also have the freedom to choose that you want to carry that time over because you don't know if you're going to need, to have that time at the beginning of the year, versus, like it's up to you. Like it's your decision. So your employer cannot make you take a payout. Like that's something that has to be voluntary. Employer requirements. So employers must keep track of each employee's hours worked, the amount of paid leave that they have accrued or provided, and hours of paid leave used and when. Employers must also include a written paid leave policy in the employee handbook and manual and give that employee manual to all employees on their first day of employment. And employers must post a Know Your Rights poster about paid leave in a place where all employees can see it. So here is a copy of what our paid leave poster looks like. So hopefully everyone has seen that somewhere in the workplace. Um, this is something that can be found easily on our website at labor.illinois.gov. So it's easy for employers to find, and it's something that they have to have posted. So filing a complaint. So when should workers file a complaint with the Illinois Department of Labor for violations of the act? So here are, the examples of, that our complaint form has. I took leave from work and I wasn't paid for it, or I was paid too little. I was not allowed to take paid leave from work. I took leave or requested to take leave from work and was fired or punished because of it. My employer did not keep accurate records of the paid leave I am owed, and my employer did not post a public notice about workers' rights under the Paid Leave for All Workers Act. So if any of those items, any of those events happen to you and you want to file a complaint, like here are some tips, on what you should do before you file with our office. So talk to your employer about any issues you're having with your paid leave requests. We're also hoping you can get a copy of that employee handbook or manual or anything that has that paid leave policy, and notification requirements, when they can deny leave, anything that provides that information. We think employees should also ask their employer to see the totals of paid leave or other leave accruals if they aren't already provided. Look at your wage records, pay stubs, online app to see if you were paid for the time you requested off. And also make sure that you gather evidence to submit, um, with your complaint. So um, here's a copy of what the online complaint form is. Like we have, your job title, job duties, whether you're still employed. The complaint form will also ask for your employer's information, their address, who's the contact person. We'll also ask for a worker's contact information, because in case we have additional questions or we want to follow up with you on your complaint, we need to be able to reach you. Um, it also there you'll see, the complaint reasons. And then we have here explain why you believe the employer violated the act. And so here we would like for workers to be as detailed and specific as possible. If you'd like to attach, a separate Word document or a separate, document outlining the exact nature of your complaint, please do so. We want to make sure that we fully understand what is going on. And that way we can make sure, it's a complaint that's within our jurisdiction and we can, help you in the most efficient way possible. So what happens once you file the claim? So I do want to preface that right now, I am a division of one person, so I see all the complaints that come in, but I'm also responsible for answering phone calls and responding to emails, as well as other duties I have at the department. So I am asking everyone, to please be patient and to thank those who may have already filed complaints or, submitted questions. I thank you for your patience as well. We, get a number of inquiries, and so we're trying to get to everyone as quickly as we can. But once you file a complaint, the complaint is reviewed by me, or another staff member here at the department. The staff member will notify your employer of the complaint, and usually that's after we've done an initial review. So we make sure this is within our jurisdiction. We make sure, for example, someone's not covered by a collective bargaining agreement, or we make sure that someone is not working in Chicago or in Cook County. We make sure this isn't related to a payout upon termination, and it might be a claim under the Wage Payment and Collection Act. Or sometimes, we get complaints and there are no violations that we can see, upon that first review. But if we decide that it merits further investigation, we will send a notice to the employer, and then we'll ask them for additional information. We'll ask them to respond to the complaint. And then that staff member in the department will investigate the complaint by speaking with you, by speaking with the employer. We may also request that either you or your employer provide additional information or paperwork. That way we can, again, get that full picture of what is going on, in the workplace as it relates to the Paid Leave Act. And so if the department finds that the employer violated the law, then they'll notify, you and your employer of the decision, and then offer your employer a chance to resolve the issue. If the employer doesn't resolve the issue, then the claim moves forward to a hearing for enforcement. And so it's an administrative hearing before an administrative law judge. Um, and then they'll make that final determination for enforcement. So complaints can be filed with the department up to 3 years after the alleged violation. So for any violation against an affected employee, the employee would be entitled to back wages, compensatory damages, a civil penalty of $500 to $1,000, and other relief as deemed appropriate. For any violation of the act except for a public notice violation, the department is eligible to collect a civil penalty of $2,500 from the employer. And for failure to post the public notice, so that little poster that we showed you earlier, the Department of Labor is eligible to collect from the employer up to $500 for a first offense and up to $1,000 for subsequent offenses. So again, if your employer is not posting that public notice, that in and of itself is a violation of the act. And so for each offense, they could be assessed that civil penalty. So again, main takeaways, the Paid Leave for All Workers Act is not a paid sick leave law. Instead, it just entitles workers to earn 1 hour of paid leave for every 40 hours worked, up to 40 hours per year to use for any reason of their choosing. And if your employer already has a paid leave policy that provides you with at least 40 hours of paid leave that you can use for any reason, then your employer does not have to provide you with additional leave time or modify their policy. You do not need to tell your employer the reason for using leave, and you do not have to find another employee to cover your shift in order to use your paid leave time. Your employer may deny a specific leave request. However, they must have a reasonable and clearly communicated policy explaining the reasons why that request was denied for operational necessity. So, if you have any questions, you can always feel free to send us an email at dol.paidleave@illinois.gov. And we also invite you to visit our website at labor.illinois.gov. We just updated our frequently asked questions section. So hopefully, in case you have a question that we don't get to answer today, you can always feel free to visit our website, and it's possible we may have an answer there for you. Um, but that concludes my presentation. So I have my colleague also here, Elizabeth. I don't know if we have any questions in the comments section that I can answer for anybody.
Thank you, Lydia. So not seeing any questions on the Facebook Live right now, but we'll give folks a minute or so to get your questions in. There was one in the chat which I addressed. There was a question about the information being provided in Spanish. Currently, we do have a presentation that we recorded a few weeks back in Spanish, but we will certainly be posting another Facebook Live with the presentation in Spanish, so that'll be coming in the coming weeks. So stay tuned on our social media channels as well as here on Facebook, where we will post the next date and time for that Spanish presentation. And with that, not seeing any additional questions come in on the chat. So I think we're safe to close out, Lydia. Thank you.
Okay. No, I think that sounds great. So, thank you again, everybody, for joining us. Hopefully, you found this presentation informative. Again, please feel free to visit our website, labor.illinois.gov, as well as, if you have questions that aren't answered on that on the website, then please feel free to send us an email with a question, dol.paidleave@illinois.gov. Again, we just ask for your patience as we do try to answer everybody's questions in a timely manner, but we are a small but mighty group of people who are passionate about the work. So just please be patient with us. We will get back to you. But other than that, then thank you, everybody, and I hope you have a good rest of your night. Have a good evening.